You can patent inventions that are virtually useless. There is a utility bar, but it is set very, very low in the United States and in most other countries. So, virtually useless inventions can be patentable. There are patented inventions in the United States, such as a fried egg-shaped cap. In other countries, there have been patents, for example, of an eye protection for chickens. Some patents are so useless that they fail the test. For example, a perpetual motion machine that was supposed to have energy efficiency of greater than 100%, but actually had 77% energy efficiency, actually failed the test on grounds of utility. Filing for a patent takes years. A patent is good for 20 years. But the clock starts ticking when you actually file the application, not when the patent is issued. And the process of getting the patent issued from the application can take 3, 4, 5, 6 years or even longer. The time really depends on the category of invention and the number of examiners that are currently available in the patent office. You can file a patent yourself. There are books available to help you do this. However, experienced inventors use patent attorneys for several reasons. The attorneys are specialists at hitting the filing dates and deadlines. They're accustomed to dealing with patent inspectors. They may be able to expand the scope of the claims in the patent to give you more protection. They're more likely to get the patent approved, and it's more likely that the patent will be enforceable in court once it is approved. The cost of patenting is similar to the cost of buying a new car and maintaining it over 20 years. You should set aside something in the region of $20,000 per patent, depending on your company, the nature of your business, the nature of the technology you want to patent, and so on. Most of this actually goes to the patent attorney. They would take probably $15,000 or more of the budget. The filing fees for the patent office are relatively low, especially for small companies, small startup entities. However, the maintenance costs increase over time, so that when the patent is 11.5 years old, then there's a maintenance fee of $1,900 that must be paid to the patent office in order to keep the patent alive. When the patent inspectors send you a letter during the process of patent prosecution, this letter is called an office action, and the lawyer will respond to that on your behalf. And just as an example, you can expect the patent attorney to charge you something in the region of $2,000 to $5,000 for each office action. The United States is a first to invent system. So regardless of who was the first to file for the patent, if there's a dispute as to who the patent should be awarded to, then the patent office runs an investigation called an interference, where it examines the records, the witnesses, the evidence, to determine who was the first person to invent. And that is where the patent will be awarded. Once you have an invention that you want to patent, it's a good idea to file the patent application as soon as you possibly can. In fact, if you put the patent in public use or on sale for a period of 12 months before you file the patent application, then the application will be declined. There's a 12-month public use and on sale bar to patent applications. However, if you disclose the invention to another party through an NDA and clearly define in the NDA that the patented invention is not actually on sale, then this can allow you to disclose the invention without triggering the 12-month period. So it can really extend the period before you're forced to file for patent protection. A provisional patent application is a relatively new form of protection for inventions, which is very simple and inexpensive to file, and which allows the owner to use the term patent pending for a period of 1 year. However, a provisional patent application does not become a patent It expires at the end of 1 year and cannot be renewed or extended. With witnessed evidence of the date of invention, there's no need for a provisional patent application. This can be achieved with a witness laboratory notebook containing the description of the invention, the date and signatures of witnesses. Remember, in the US, if 2 applicants are seeking a patent on the same invention, the patent is not necessarily awarded to the first to file, but is usually instead awarded to the one who was first to invent. Establishing priority of invention can be achieved through a laboratory notebook rather than a provisional patent. An abstract idea is not patentable. The idea must be so clearly defined in the inventor's mind that only ordinary skill would be necessary to reduce the invention to practice without extensive research or experimentation. So the process of conceiving an idea, actually involves providing significant detail and thinking through clearly and expressing very clearly how the patented invention will actually work. It's important to take care when talking about your inventions. You don't want to trigger the 12-month on sale bar or trigger the public use bar. So use NDAs and select your words very carefully so that you are not seen as putting your invention in public use or on sale. One of the core elements of the patent system is that you have to enable others to build your invention. This is the enabling requirement. So you need to provide a written description that explains in detail the process of making and using the invention in full, clear, concise, and exact terms. The description needs to be sufficient for a person with ordinary skill in the art to make and use the invention without having to go through undue experimentation of their own. Jerome Lemelson and his heirs collected over $1.3 billion in royalties from what became known as submarine patents. He would file a patent, leave it unissued, continue the dialogue with the patent office for 20 or 30 years. During this time, the patent was not disclosed to the public. Then, when an infringer appeared on the scene, he would have the patent issued, and then when it surfaced, he would commence legal action to enforce his rights against the potential infringer. And in this way, he generated over $1.3 billion. This has been stopped. Now patents have a 20-year term from the date at which they're filed, not from the point at which they're actually issued. And the other amendment is that the patent applications are now disclosed, so they cannot be concealed from the public. Anyone can request a patent re-examination for a fee. So if your competitor has a patent awarded, you're able to approach the patent office, pay a fee, and have the patent re-examined. If your patent application is rejected, there is an appeals process. The first step is to go to the USPTO's own Board of Appeals. If that is unsatisfactory to you, you can then move to the Court of Appeals for the Federal Circuit. This is a special federal court that's established to deal with patent cases. If your dispute is with the Patent Office itself, you could bring the case to the District Court in D.C. where the Patent Office is housed. The U.S. Supreme Court can hear patent cases, but does so very, very rarely, so this is not an option for most patent applicants.